Hi, everyone. Thanks for joining us for our annual marketing compliance overview. We'll be discussing regulations that were passed last year in 2024 and also look at pending regulations that are coming up in 2025. I'm Eric Tejeda, Vice President of Marketing for Possible Now, and our presenters today are Steve Neidick, Director of Marketing Compliance, and Tony Jernigan, Marketing Compliance Consultant for our sister company, Compliance Point. And just so you understand who they are and what they do, Possible Now provides compliance-related technology, and Compliance Point provides consulting related to marketing compliance regulations, and they help their clients operationalize those regulations within their organization. Two notes before we get started. We will have a Q&A at the end of the webinar to answer any questions that you may have, and we'll also send out a recording of this presentation. So with that, Steve, please get us started.
All right, Eric, thank you for the introduction. My name is Steve Neidick. As Eric mentioned, I'm the director here at Compliance Point, actually celebrating 21 years this month. And with me is Tony Jernigan. Tony, you want to say hello?
Hi, hello, everyone. Yeah, I'm happy to be here.
And thank you all for joining us very much. We know everyone's got busy schedules, so we appreciate you joining us on this. Should be an informative webinar.
Yeah, we're going to just, looking back at 2024 and ahead to the rest of the year. We're just going by very quickly so far. We're going to look at all of the activity within the FCC as well as the FTC, as they both regulate our world, of course. We'll take a look at where we think Congress fits into the mix or might fit into the mix. Then we'll look at what's been happening and might continue to happen on the state level. And then, finish up with general trends in litigation and leaving time for questions, as Eric mentioned.
And we have to throw this out here, as all you've seen these on other decks as well. We just have to make this quick legal disclosure. As you know, this presentation isn't legal advice, shouldn't be substituted for legal counsel. You should seek your own attorney for opinions regarding matters of law. Had to get that in there. So let's jump into it. One-to-one consent rule. This was the big news of 2024, and even bigger news to start 2025. Tony, you want to give us a overview of this?
Yeah, absolutely. I mean, what would be a legitimate regulatory compliance discussion without leading off with one-to-one consent, right? Mm-hmm. That's all we've heard about for over a year now. And I have to share that probably my most favorite anecdote from all the various articles that I read this past year, and I don't remember now who this was, but it was from apparently a new dad who said that he was worried that his newborn might learn the words logically and topically related even before data. So that's got to be my most favorite anecdote.
I haven't heard that one.
Yeah. Yeah, as many of our listeners probably know by now, is the rule is dead for now. It would have, just to recap, it would have required sellers and callers to obtain individual consent from consumers for both robocalls and robotexts that must also be logically and topically related to the initial interaction. So, if I'm looking for homeowners insurance, I shouldn't be getting a call from a roofing company as one that I never heard of, right? That may not even been identified in the list of companies that I would hear from, for example. So as many probably know, the last business hour on the last business day, which was the Friday before the rule was to take effect on the following Monday, the 27th, the FCC issued a stay on the rule for up to 1 year. And then the 11th Circuit Court of Appeals basically said, hold my beer, and overturned the whole thing.
Like literally 10 minutes later, wasn't it?
Right, within a few minutes, yeah. I've heard varying times, but I think 10, we'll go with 10. So it's basically dead for now, right? The Insurance Marketing Coalition, or the IMC, had petitioned the 11th Circuit Court of Appeals for a review of the rule, and the court basically agreed with all of the positions from the IMC that they presented, which was that, the FCC overstepped its statutory authority. The TCPA doesn't define prior express consent and the FCC's proposed definition would have contradicted the plain meaning in the common law definition. And finally, that, as long as consumers' consent is given voluntarily and clearly, they can authorize communications from multiple entities at the same time, even those that may not even be logically or topically related, just as long as they know who, you're managing consumer expectations and they're going to hear from people that they expect to hear from.
Let's throw this out here real quick, Tony, because I know a lot of people put a lot of work, spent a lot of time making sure that they were set, talking to their lead gen vendors, and making sure that they were set for this rule. I don't think you can just toss that aside. I think it's still a good idea. You've spent the time and money and effort to make sure that you're complying as if it did go into effect. And it's probably still a good idea to go down that path, because nothing frustrates customers more than, signing up for something they think is going to be a mortgage lead, for example, and then they're starting to get calls about window replacements and home security systems and things like that. So, it's still a good idea. You might get more qualified leads. You might have less complaints because consumers are expecting those calls. So it's not necessarily a bad thing. You don't have to throw out all the work you did on this.
100%. Absolutely agree. At the end of the day, the court said that, clear and unmistakable, they use the terms clear and unmistakable. And, that fits in with the standard that should still be adhered to, which is, your business entity should be identified clearly and conspicuously, and explain to the consumer, who they're going to hear from. So absolutely, excellent point. But by the way, now the court or the panel that heard this and ruled and overturned the rule, it was a panel of 3 judges, right? The 11th Circuit Court of Appeals is comprised of 12 judges, and as is often the case, these types of decisions are heard by, a abbreviated panel of number of judges. So in this case, it was 3. And just recently, we've heard that the National Consumer Law Center, on behalf of 4 small business owners, have asked the same court, presumably the entire court now, en banc, which means the whole court, for permission to intervene and basically reconsider it. So it's hard to make a prediction as to what will happen. So we'll have to wait and see. But Steve, that's an excellent point, right? I mean, we recommend that, just, don't throw all the time and energy and effort out the window, right? Just continue to make sure that you have consent to call the consumers.
Yeah, exactly. It's better, I think, to be transparent too, right? Again, if someone signs up and puts their name, address, phone number in a lead form, they should be, they have expectations of who they're going to hear from. And you still should look at your lead sources, all of them. We still recommend vetting those because, in our world, we've seen some of our clients and heard about others that are buying leads from, I would say, questionable lead sources. And an example would be, a lead gen that's pushing out pages, trying to get surveys to ask people what, and this is a real form we've seen, is what's your favorite M&M color, right? And someone fills out their information and submits it. But in the small fine print was a list of you're giving your consent to our marketing partners, and you click on that partners link and 2,000, 3,000 different company names come up with everything from A to Z about products and services. Right. So it's still not a good idea to buy leads from sources like that.
Exactly right. And by the way, there was a case that I covered in one of our marketing updates, I think it was almost a year ago, where, and I forget now who was involved or the state, but basically, the plaintiff brought the action saying, I'm on a do not call list. This entity did not have permission to contact me. And the defense was that, well, you provided consent on this web form. And then when they looked at the web form, it was exactly as you just mentioned, that, it was, the entity was buried in a list of hundreds, if not thousands of other entities. And the court even said at that point, this is not clear and conspicuous. So, I mean, you can potentially run afoul of this, without, having this particular rule in place.
Yeah, and even pushing out, I've seen this in the past too, pushing out a program as a quote unquote survey where they're asking you, what's your favorite place to vacation, mountains, beach, overseas, things like that, and then getting those leads and selling them to timeshare companies or vacation planners and pushing out those leads where those will obviously generate calls to those consumers who thought they were filling out a survey, not necessarily giving their information to marketers to call them on the phone. So still have to be very careful with all of this.
Right. And then just to conclude this slide, the assault on the FCC's authorities is not done there. There is another case that's hanging out there where the Supreme Court has agreed to hear a case to decide whether federal district courts, now those are the trial level courts on the federal level, must follow the FCC's interpretation of the TCPA. And just to be real brief, this all stems from I think the case started in 2013, where the plaintiff, which was the Chiropractic Associates, McLaughlin Chiropractic Associates, alleged that McKesson Corporation violated the TCPA by sending unsolicited promotional faxes that included both traditional fax machines and online faxes. Years into the case, I don't know why it went on that long, but years into the case, the FCC issued an order basically changing the definition of what an online fax service is under the TCPA. And it basically blew up their class action suit. And the district court, feeling as though it had to adhere to or pay deference to the circuit court, basically said, yeah, we can't review this. And because, the FCC's rule is the gospel, if you will. And we can't review this. And so, it's made its way up now to the Supreme Court. So, the Supreme Court's going to hear this and, potentially, the bottom line is if the Hobbs Act gets overturned, then, district courts or, again, trial level courts, they would be freer to interpret what the rules mean. I mean, so the way I don't know about you, Steve, but the way I look at this is that, at least with the way that it is, right, you may not like it where you stand, but at least you know where you stand, right? Now with this, potentially with this, you're going to have different courts across the country deciding that these rules mean different things. And so you're back into a situation to where you have to think about, well, I'm going to have to probably opt for the most conservative position to begin with, right?
Absolutely. It's definitely going to complicate things and make it tough to figure out what do I need to comply with, for sure.
Right. All right. I think we can move on there. So the next FCC's rule that will be coming, part of it went into effect actually last year, and the rest of it will be going into effect this year, is the consent revocation rule, right, which is designed to enhance consumers' ability to revoke consent for receiving robocalls and robotexts. Again, it's set to take effect on April 11th, 2025. And basically, in a nutshell, it means that, consumers find themselves finding this very easy to opt into this stuff, right? But, they want to make it as easy to opt out. So the rule will be that, basically that people can revoke their consent by any reasonable method. And these, would include, using automated interactive voice or key press, via website or telephone number, emails sent to email addresses, for example, so you just any number of different channels or avenues where you should be able to revoke your consent as easily as you opted in, or in some cases, maybe you didn't opt in. So one of the things that are going to be looking at is that, any phrase, and the FCC went ahead and put forth 7 words, stop, quit, end, cancel, unsubscribe, and 2 more that are not identified there, revoke or opt out. And so basically that's the, the sort of benchmark. Those are the 7 words that they'll be looking at to say that, if a consumer uses any of those, regardless of what you tell them to type in your opt-out instructions, that's a reasonable attempt to opt out. It can be phrases, right? And we saw a recent case where the consumer said, "No, duck off." And the court said that would be a reasonable wish to opt out. It could be phrases. It could be a typo. The one example that we use a lot is what if somebody says stip instead of stop, since the I is right next to the O on the keyboard, right? Foreign language, right? What if you get a message that's a response message that says no más, which, no more in Spanish. And this is a new one on me. I even heard from a client last week that they'd seen one response that was the middle finger emoji. So in an abundance of caution, they're going to opt that person out. And I would tend to agree with that.
Yeah, sorry to cut you. One of the tricky parts there is, a lot of these, at least in the past, I'm sure the technology's evolved, but one of the challenging parts for some of these is that are trying to automate the process for these opt-outs in text. And unfortunately, that's one of the tactics these professional plaintiffs take, is not following those instructions and doing that emoji, right? Or trying to trip up the system so that they continue to get text and then they can bring suits. I know of one client that sent out a text message campaign, and they weren't worried about any of the replies. They weren't trying to get replies. So if anyone did reply anything to that message, they would put them on the do not text list. So it can be a challenge. We also recommend at times, building a dictionary of opt-out words that you're looking for, which,
right.
Again, that can be challenging because people are getting creative, but, try to build a dictionary or figure out some way that you have to opt these people out.
Right. So yeah, then finally, just in terms of scope and processing, that, it technically only applies to robotexts and robocalls, and vice versa, right? So if someone opts out of calls, you should apply that to texts. And if someone opts out of your text, you should apply that to your calls. But, one of the things we hear from our clients a lot, and we're going to get into this more in a few minutes, but one of the things we hear from our clients a lot is, well, I'm not using an ATDS, or an automatic telephone dialing system. I'm not using pre-recorded or artificial voice. So how does this apply to me? And, we always advise our clients, first and foremost, don't assume you're not using an ATDS. We're going to, again, look at this again in a few minutes, but, it's for a whole host of reasons, not the least of which is that, there's still unsettled areas of the law among circuits and across the country. And also, the definitions could change. Again, I don't want to spoil our thunder from our future discussion, but we'll get to that in a few minutes. But suffice it to say that, we advise that all businesses adhering to these rules, and especially this next one, which is you should process all requests as soon as possible, but in no case longer than 10 days, right? And we hear this a lot. It's 10 days. I get 10 days. Well, no, you don't get 10 days necessarily as a matter of law. You don't look at it as a grace period. You should do it as soon as possible. The FCC has even commented that, with the more that technology advances, that, the ability to opt somebody out of communications should happen almost instantaneously. And we've seen cases where the one in particular is with Papa John's, where the consumer opted out of texts. They got another text 4 days later. They got another text 7 days later. They brought suit. Papa John's counsel filed for motion to dismiss, saying we are compliant as a matter of law. And the courts are refusing to grant these motions to dismiss at the pleading stage, right? And it's basically saying, you're forgetting a key component here, which is as soon as possible, and it should be up to a jury to decide what that means. But so what's happening? Instead of continuing to pay the money to litigate the case, they're just going ahead and settling. So we won't necessarily know what the disposition of these cases would be because businesses are opting to settle, understandably. So get those consents operationalized ASAP.
And that's a good point. Just to go back to, it's risky, as you mentioned earlier, to just assume that you're not using an ATDS, because the reality is you may win that case, and you probably would win that case, but you're going to spend a lot of time, money, and effort to try to defend yourselves, right? So even if you win the case, you're still going to spend a lot of money in legal fees to win that case.
Right. Next slide. And then this was the part that I mentioned that took effect actually last year, and that is that you do get another shot, as it were. You get to send a confirmation text to the consumer as long as it is sent within 5 minutes of their opt-out and that it contains no further marketing message. And the FCC has also said that there shouldn't be any further attempt to change the consumer's mind. And so, we as consumers, I'm sure a lot of our listeners, right? Well, I've seen situations where they'll say they opt out and they'll get a confirmation text saying you've now opted out. To opt back in, press 1.
Right.
Is that an attempt to change the consumer's mind? Probably, but I don't know anybody that wants to be the test case to decide. So, we wouldn't necessarily recommend saying, do this to opt back in. Now, you do get to ask the consumer to provide additional clarification if you've gotten them to opt in on a categorical level and basis to begin with, right? So if you've said, what kinds of messages would you like to get, about this product or that product or this for this purpose or that purpose. And then if they opt out of a certain type of a text message, then you can send a clarification message within 5 minutes that says you've opted out of this. Did you also want to opt out of this, or did you want to continue getting these? If there is no response, or at that point, basically you have to treat everything as an opt-out, right? But unless you get a response saying, no, you can continue to text me about this or that or whatever, then you have to treat that as a blanket opt-out.
Yeah, I think the key factor there, though, that you mentioned is as long as you're opted in that way, right? So if you have a broad consent statement that says you are consenting to receive phone calls, text messages, pre-recorded messages, and that kind of thing, and then you get that opt-out, you should treat it broadly as well.
Right. Next slide. So, artificial intelligence, AI, that's something that we hear in everyday parlance, right? Probably about a year ago, February of last year, the FCC issued a declaratory ruling saying that AI generated human voices are artificial or pre-recorded voices for the purposes of the TCPA. And then later on, they proposed a new rule. This has not gone into effect yet, where this is the bullet points that we see here, right? First, they're defining an AI-generated call as those using technology to create artificial or pre-recorded voices through computational methods, machine learning, or predictive algorithms. You would be required to ensure that this is included in your consent language, right? So you'd have to be required to clearly inform consumers in your consent language that they're also agreeing to receive communications that are AI generated. And it has to be at the beginning of your calls or in your texts, right? So you'd be required to clearly inform consumers at the beginning of a call if AI generated technology is being used. And then also, you can understand this, right? I mean, where people, nefarious and folks out there, could be trying to use this, for fraudulent or nefarious purposes. But, but understand too that, they're trying to strike a balance here between, keeping people honest, but also promoting AI and access to telephone services, especially for individuals with disabilities. So that's the the balance they're trying to strike.
Yeah, I think a lot of it's the same. I mean, AI is obviously an artificial voice, and the rules, a lot of the rules have always stated you need certain consents and things like that to deliver artificial voice or pre-recorded messages, right? So from that aspect, it's not really changed that much. But things you mentioned, phone calls and text, but people also need to be aware of other communications as well, such as, a lot of companies, customer service purposes will have, or even sales, I guess, will even have chat bots on there.
That's right.
So, exactly. Don't forget about those chat bots in addition to the calls and text. So if you're using AI to kind of drive those chat conversations, you need to make sure you're disclosing it there as well.
Yeah, it's California, right, that has a pretty robust chatbot law.
Yeah, exactly. Exactly. All right, we want to get into the FTC and the telemarketing sales rule update.
Sure. FCC's done a lot. It's time to move on to the FTC. So, this was a rule that went into effect last year. So many of the listeners may already be aware of this. But again, this is a look back and a look ahead, right? So basically, this rule that went into effect last year increased the retention period from 2 years to 5 years. Compliance Point actually always recommended that you keep these records for 5 years, but now it's a rule under the telemarketing sales rule, or TSR, that you should keep these records for 5 years. And not only that it increased the amount of time, but it also increased the scope of the records, some of which were would consider to be eyebrow raising, right? So, they want you to keep the caller. These are just a few of the highlights. There's many others. And, we have a template, of course, that we provide our clients that, spell out all of the requirements. So caller ID, you need to keep your caller ID that was used, your outbound caller ID number that was used for each campaign, the name and the number on D&C requests, of course, as well as the date that it was made, that you got it. And then another example is that all campaign activity, including dispositions of each call, kept to the closest second of the time of the hour, right? And the length of the call and the date and the time of the calls, etc. So it's it's pretty onerous.
Yeah, I think the good news with this is a lot of companies already keep a lot of these records, so there shouldn't be too many changes. It's just the important takeaway here is just to review all of your record keeping, but also importantly, make sure you can access it in a quick manner, right? You don't want to have things in archives it's going to take 3 weeks to find or try to produce. I mean, make sure they're readily available and you can produce it in a fairly quickly manner, because again, record keeping is your only evidence in defense and against some of these claims. And if you don't have the records, you really don't have any defendable position.
Exactly right.
All right, so will Congress act? We saw some proposed changes back in January of last year with the Do Not Disturb Act. Tony, you want to give us some highlights on that?
Sure. So this is sort of where I was going before, right? With don't assume that you're not using an ATDS, because with the Supreme Court's decision in 2021 and the Facebook decision that we hear a lot about, right? They narrowly defined what an ATDS is, such that it probably excluded most, if not all, current platforms that were in use, right? So it was good news. And but then, not to be outdone, within a couple of months, Florida proposed a law that said you need to express written consent for an automated system that selects or dials a number, right? So we see that as, or it was proposed that it was sort of an attempt to fill the gap, right? Because you've got the definition from the Supreme Court of what an ATDS is, and then you have the FCC that keeps posing and enacting new rules that say these rules apply to regulated technology or an ATDS. And so the question continues is like, well, this doesn't apply to me. And this is, again, this is why we recommend that, don't assume that you're not using an ATDS. And so I think that there will be, especially with all of the concentration and attention that the one-to-one consent rule has gotten, is that, there will be an attempt to sort of close that gap between, with the rules and the kind of equipment that you're using. So last year, as you mentioned, the Congress proposed what was called the Do Not Disturb Act. And it's sort of a radical proposal that they proposed changing the definition of automatic telephone dialing system with a definition of robocall. And I'll just go ahead and read this because I think it's that important. A robocall would be a call made or a text message sent using equipment, whether hardware, software, or a combination thereof, including an automatic telephone dialing system that makes a call or sends a text message to stored telephone numbers or telephone numbers produced using a random or sequential number generator, or using an artificial or pre-recorded voice or an artificially generated message. The term robocall does not include a call made or text message sent using equipment that requires substantial human intervention to make or send the call or text message. So we would be back to pre-Facebook decision era, right? Where everyone was wondering, well, how much intervention is enough intervention to say that, we're not using an ATDS. So, obviously with this language, it would bring many more platforms and calls into the scope of the rules. Also, very startling was a proposal that that calling hours would be reduced from the current federal standard, which is 8 a.m. to 9 p.m., that would be reduced to 9 a.m. to 5 p.m.
I can't imagine that'll go over very well.
Oh, I know. I mean, everybody, it was almost like, so many different clients and businesses were just zeroed in on the 9 to 5 thing, and they didn't even care what kind of equipment they're using. So they were more concerned about the 9 to 5 thing.
Mm-hmm.
So also you see some other, again, this is not all of the elements of the proposal, but it would also, similar to what we see with the FCC now, it would require disclosure of the AI used at the beginning of calls. It would have doubled the maximum torture penalty or criminal fine for violations where AI was being used for the impersonation of or with fraudulent intent. And then finally, it would have asked the FCC to track and publish a monthly list of the top 100 illegal robocall campaigns. So will this be reintroduced this year? We think it's likely. We now have a Speaker of the House with the Republican majority. We have the Speaker of the or excuse me, not the Speaker of the House, the Senate Majority Leader, John Thune, who is no stranger to telemarketing issues. He was a co-sponsor of the Trace Act a few years ago. So again, with the attention that these rules are getting, and the fact that they've already indicated that that they intend to act, we see that it's a possibility, strong possibility that the FCC or the Congress will get into the action and propose some new legislation. And if there's one thing that we always say, that if there's one thing that politicians can agree on, right, from both sides of the aisle, it's probably to for the effort of combating telemarketing calls.
Yeah, absolutely. And I can tell you there's that top 100 list. That's a list you don't want to be on.
Right.
All right, let's get into some of the state level developments. We've seen an influx of many TCPAs. This isn't just in 2024, so it's over the last couple of years, but you want to dive into this a little bit, Tony?
Well, yeah, I mean, it's still along the same lines of who's going to fill the gap, right? Or who's, so, again, with after the Supreme Court decision with Facebook, we saw that Florida got the ball rolling, as I mentioned previously. And then Oklahoma and Maryland passed copycat laws. Florida wisely, we think, walked their language back a bit and changed it. Initially, it was calls with automated systems that selects or dials the member need express consent. But they changed it to and, which we think is closer to the TCPA, but still not identical. But Maryland and Oklahoma, still have the or language. Oklahoma has a whole host of exemptions. Maryland does not. There's only a handful of exemptions. So, we always tell clients that don't forget about Maryland. Don't forget about the state mini TCPAs. And by the way, I think it's important too that we think about what we mean by mini TCPA. You see that term actually thrown around a lot by a lot of different people in the space, and some people use it to mean any law that is proposed on the state level that has to do with any element of the TCPA, right? Even if a state proposes reduced calling times. But we generally look at it as one that has that more expansive definition of what an automated system is, right? That would include more systems or more platforms into the scope of the law. That's usually the kicker for us in terms of what we mean by mini TCPA. West Virginia proposed one, was stalled in the Senate. Just this past December, South Carolina proposed one, and it mirrors these other ones. It would require prior express written consent for calls with automated system for the selection or dialing of telephone numbers, playing of a message or pre-recorded voicemail. When Florida walked their language back 2 years later, in 2023, we wondered what impact that would have on these other states that still had the or language, and apparently none, because there we still new laws now, like South Carolina, that are still proposing the or language. Generally, these laws also reduce an hour of calling time at the end of the day. So instead of reverting to the federal standard, which is 8 to 9, they cut off an hour and make it 8 to 8. And then not only that, but you only get 3 attempts in 24 hours. Again, 24 hours is not a calendar day, right? So it's not like you can make 2 attempts in the afternoon of one day and 2 attempts the next morning. And it also is inclusive of calls and texts.
So it's a combination thereof. If you're going to
Right.
send 2 calls, you only have 1 text, 2 texts, you have 1 call.
Right. Exactly right. So we got to, we tend to see this a lot where states are proposing stricter caller ID regulations. Tennessee and Illinois were 2 that came up last year and passed. Trying to address misleading caller ID and reinforcing prohibitions on spoofing. So you see states continue to act in that regard. And then also we've seen a few unique proposals. A couple come to mind that they didn't pass, but it's important to keep those to remember them, right? And because you never know when these can get traction somewhere else in a different state, or they could be reintroduced, or one little key component could be addressed that was a halting point for somebody in the legislature, and then that gets addressed, and then it gets reintroduced and passed. We did see last year that Illinois was the first state to propose that 3 attempts in 24 hours that we just talked about, without the accompanying automated system, right? Everywhere else we've seen the 3 attempts in 24 hours, it's been part and parcel to that overall law that also includes the more expansive definition of an automated system. But this was the first proposal that we'd seen that was where it was just sort of on its own, that but it didn't, for whatever reason, it failed to progress through the legislative process. And then the other one that I was going to mention there too, Steve, I know you'll remember that even Mississippi used to be one of the 12 states that had their own DNC lists. And then a couple of years ago, they said, we're not going to maintain our own DNC list anymore, and we're just going to merge our list with the federal registry. And then lo and behold, the following year, last year, I think it was, they proposed what we would consider to be an atomic DNC list, right? That if you put your number on this list, you shouldn't get any calls. Even with express written consent, businesses would not be able to call you if your number's on this list. Basically, no exemption type thing. right?
Yeah, and one of the questions we get from a lot of clients too is we'll send out, the holiday calling time restrictions every month, and for years and years and years, it's always included Mississippi, and if you happen to get that calling holiday restrictions chart and see Mississippi's no longer on there, why is it? Did you all forget it? It's we didn't forget it, but that part of the restrictions were tied to the state do not call list. So essentially, when they got rid of the state do not call list, they also got rid of those holiday calling prohibitions.
Right.
All right, moving in. Did
I'm
you have
sorry?
something you want to go back on that other slide?
No, not
Okay.
at all.
Litigation trends. Again, this is becoming more prominent, and we are seeing a shift away from, these TCPA class action lawsuits against companies for calling cell phones with non-ATDS. We're starting to see them go back to just the good old DNC list violations and things like that. So there's definitely a new litigation focus. You want to talk a little bit about that?
Yeah. And we're continuing to see these in with new areas, right? New things that, previously we would have said, well, larger scheme of things, this is probably lower risk, right? Not don't ignore it, but it's extremely low risks. So for example, texting too early or too late. Texts are generally viewed as less intrusive of calls. But here now we've seen a situation, there are two cases represented by the same South Florida law firm, by the way. What does that tell you? Where two different consumers, and they're able to provide the screenshots of when these texts came in. In one case, the plaintiff alleged that they're a resident of California. And this is the textiles case, right? Textiles being the sort of online company that will take your photos, your family photos, and turn them into like a canvas type thing that hangs on the wall. And I'll stop there because I don't want to do any more disservice to their business. And so they are actually, I think, based internationally, but they're incorporated in Delaware here in the U.S. But this consumer said that they lived in California and they got a text message like at 6 o'clock in the morning, roughly. And then the second case was one where a Florida resident got a text at 9:04 p.m. So, an hour and four, because the Florida calling time ends at 8 o'clock. So it was an hour and 4 minutes later. But, and this is another example, right? Similar to the Papa John's case that I mentioned earlier, where we're probably not going to find out any kind of a disposition based on the facts of the case as to whether the consumer provided consent, if the consent meant that you could text outside the calling times, because they're probably going to go ahead and opt to settle before the court before the cases are decided on their merits. So. Yeah, and it's and
But
more and more.
Yeah, just a piece of advice, I guess. I mean, because more and more people probably are. I don't do this, but more and more people probably sleep with their cell phones right next to their nightstand, and so the takeaway is try to call based on what those calling time restrictions are, based on address as opposed to area code if you have it.
Right. So some more key cases. We've heard a lot about Bradley versus dental plans. That sort of upended, the industry a little bit, right? Many in the industry would have said, prior to a few months ago, that if you get verbal consent on a recorded line where your agent has covered all of the essential elements of express written consent, that you're golden, right? It's basically a verbal version or an oral version of express written consent on a recorded line, and as long as you get the consumer's affirmative yes, right, not a or anything like that. But then a federal court in Maryland said that oral disclosure doesn't meet the requirements of the E-Sign Act. And it's not lost on me either that the TCPA doesn't say that consent has to be in writing. It's prior express consent, right? It was the FCC who said that it needs to be in writing. So but in this case, you can't blame the FCC, right? It's a court that says basically based on this rule of the FCC's that it has to be in writing, that it doesn't meet the, the requirements of the e-sign Act. So that's being appealed, and, more to come on that. You're going to say something, Steve?
Nope, go for it.
Oh, sorry. And then also Perong versus All-Star Chimney Solutions. There again, previously we would have said this is kind of low risk, but here our court said that failure to be able to provide a DNC policy was considered to be a further violation of the TCPA. So there's just a reminder to make sure that each and every component of the TCPA, especially those that are outlined under the safe harbor requirement, right? That you have policies, that you train on those policies, that you have adequate suppressions in place, and monitoring and enforcement, and that you keep records of all this stuff. That you need to be doing all of this stuff in order to make sure that you don't find yourself in one of these, sort of newer focuses of lawsuits.
Sure. And just a word of caution where you're mentioning failure to provide a DNC policy, because we have some clients, we do, assessments, gap analysis, and we find occasionally some clients that says, yes, we have a do not call policy. Great. But then we ask the next question, how do you deliver it upon request? And sometimes they'll say, well, we'll just email it to them. And we always advise against that. We propose you either send it registered mail or even just regular mail, because then you can assume that they got it. Because what these professional plaintiffs sometimes do is claim, I never got an email with this policy. And, and it could happen with spam filters, and a lot of the email providers now, might put an email you receive into a spam filter, and they might not ever see it. So we always advise, keep records of who you sent it, when you sent it, and then deliver it via mail in some form.
Right. The more that professional plaintiffs have come, their activity keeps increasing, and you see, there's schools around how to be a professional plaintiff, right? Yeah. I think more and more courts are recognizing, the extent to which some of these lawsuits are being manufactured, where these people are setting out to, purposely trip up the compliance efforts of businesses. And so I think that's being recognized more by the courts, and, and being, dismissed.
But unfortunately, not by all of the courts, right?
No.
We've run across some filings that they've filed, 129 cases within the last 6 months, things like that. And they're doing everything they can to try to trip you up. I mean, they even enter information to a lead form, and may even change, through a VPN where it looks like their IP address is in Oklahoma, but they're actually in New York. So right. There's every tactic imaginable, and they're always getting creative. So we just have to try to stay on top of things like that. And again, it comes down to record keeping and evidence.
Right. Yeah, we heard an example. I heard an example from our colleague Kevin Mayfield last week, where one guy apparently was using the information of his neighbor, right? And maybe, who knows, to the extent to which this, the nefariousness went on, but, maybe he convinced this person to give up their phone. And, he was probably filling out lead forms under this neighbor's name, right? And then you have to, when a person gives up a number, it has to be rested for 45 days. And then 45 days later, he got the number, right? And then just waited for the phone calls to roll in and say, this is not me. So this illustrates the importance of subscribing to the reassigned number database.
Yeah, absolutely.
To make sure you're calling the right person.
Sure.
And then finally, registration, right? This is another area where, a lot of businesses will tend to, put it on the back burner. But, at least in Texas, we know that now that there's a private right of action, and it has proposed some legislation that puts more teeth into it. where a consumer can file under a private right of action if they got a phone call from a business that is not registered as a telemarketer solicitor in Texas. And it's public information, right? You can access a website and see who's registered and who's not. So make sure you get registered. And you know that there's 34 states plus DC that have some form of registration requirement. All of these states have various exemptions. They're not all uniform among all the states. But unless you qualify for an exemption, like you're a publicly traded company, it's, you're only doing business to business, you're only calling to set up later face-to-face meetings, you're only calling with express consent, then you need to register in these states too to make sure that it says at least Texas to make sure that you don't get in trouble.
Exactly. And if all this weren't enough, kind of to wrap things up here, I mean, we have all of these rules and regulations coming from the states and at the federal level. What we're also starting to get questions about are the difficulty that some of these carriers or service providers, such as, phone providers, texting providers, email providers, to deliver these messages, they're coming out with their own more restrictive rules that maybe even go above and beyond what the regulatory requirements are, right? So we're seeing things, for example, that you have to have unchecked check boxes that are separate for calls and texts and emails. And some of these carriers, which again, you're not going to get fined, but the way it's going to hurt you is that if you're not following their rules and complying with what they say needs to be done, they're simply just not going to deliver your messages. So
Right.
We're keeping track of that. We know texting is becoming more and more popular. So we're watching these carrier rules too, just to add on top of the federal and state regulations, as if that wasn't enough, right?
Yeah. Excellent point, 100%.
Steve and Tony, thanks for your insights today. If anyone has any questions, now's the time to put those in the chat pane, and we'll start to go through those momentarily. And as a reminder, we will send out a copy of this webinar recording for you, and that way you can reference it in the future or share it with other people in your organization. All right, let's jump into the questions. Steve, I'm going to combine these first two because it looks like they're related. One was consent for what? Just marketing calls and text? That was question number one. And the other one was, is opting a customer out of their consent to receive marketing information, should those revocations of consent be treated as a do not call request, or do you just remove the consent?
Yeah, and they're kind of similar answers, but I'm assuming, so we're talking about the consent for what? Just marketing calls and texts. That was on the revocation of consent slide. So, I mean, technically, if someone opts out of an informational marketing or an informational non-marketing text, pretty safe to say they probably don't want marketing calls or texts either. So I would apply those to both. Now, if someone's opted out of marketing, can you still send them an informational text? I guess the answer really depends on how did you, almost like how do you get those opt-ins? If you have a broad consent, right? So you have a consent that says, I agree to receive calls, text messages, pre-recorded messages, emails. If it's that kind of broad consent, then we advise opt them out of all of those, right? Because it was a broad consent, make the opt-out broad. And then to address the other question about should revocation of consent be treated as a DNC request, again, on marketing calls, someone revokes their consent, and I think we're going back a few years now to the old days. I mean, we've heard that revocation of consent term for many years now, and it used to be more applicable to calling cell phones with an ATDS. You could revoke your consent, and it would apply to, I don't want these automated informational calls anymore. Obviously, again, you would think someone wouldn't want marketing calls either. So the safest course of action here is, yes, to treat it as a DNC request at all, especially if it's a marketing. You can remove the consent, but then again, they're on your internal DNC list, so they shouldn't be called at all there. So hopefully that answers your question. If not, follow up via email, and we can address it in more detail with you.
Okay. So this one looks like, I'm going to throw this at you as well, Steve. With respect to the new revocation of consent rules, do you think with with their comment about any reasonable means could also mean someone telling a cashier in a retail store that they want to be put on a retailer's do not call list. Would that be in scope?
Again, it's a case by case basis. I can't imagine that would get upheld in court. I mean, you walk into a Target and tell a cashier you don't want any text messages from Target. There's a lot of cashiers at Targets, right? And so I wouldn't say that would be any reasonable means. But we'll certainly watch for cases like that and see if any courts disagree with that. But
Well, it'd also be tough to prove.
it would be tough to prove.
There's no audit trail.
And telling a cashier, I think they're more trying to apply that rule to any reasonable means, meaning, if I type stop, quit, those keywords were listed, but then also add like, take me off your list. So even if things don't follow those keywords, use your reasonable judgment that if someone says, take me off your list, that you don't call them anymore, that kind of thing. So telling a cashier you don't want any more text messages, I personally don't think that's a reasonable means, and I don't think any courts would either, but we'll watch it.
Yeah. All right, Tony, I'm going to throw this one at you. Do you think that states will come up with their own one-to-one consent rules after this recent attempt was vacated at the federal level?
Well, that's an interesting thought and question. It's certainly a possibility, right? I mean, we did see states start taking action when the SCOTUS narrowly defined an ATDS in the 2021 Facebook decision that we spoke about. So I think it's certainly a reasonable inference. But so far though, I think we're just in a sort of a wait and see period. But I think there are a number of possibilities. One, I suppose the FCC. I mean, there's one school of thought out there that says the FCC could take another stab at a new rule and try to come up with something that better addresses the court's opinions. That's more within their scope. As we talked earlier, Congress could act, or as the question suggests, the states could act. But it's also going to be interesting to see what happens of the petition I mentioned earlier, right? That was filed by the National Consumer Law Center on behalf of the National Consumers League, which is that's America's oldest consumer advocacy organization, by the way. Just a piece of trivia, but it's again, I just think we're in a wait and see period. But
okay, okay. So the next question is allowable calling hours reduction. Does that supersede collections, the FDCPA? Which says 8 to 9. And Tony, I'll let you take that one.
Well, first of all, if we're talking, I think it's important to remember the congressional bill that we spoke about earlier, right? That was only proposed and it didn't go anywhere last year. So if it or something similar would have to be reintroduced. If you're talking about more restrictive state laws that reduce allowable calling times, those are generally specific to marketing calls, right? Not debt collection. So we'd think that the debt collection would still be, 8 to 9. But, we'd have to see if anything becomes of the, if anything becomes of changing the calling times on the federal level relative to Congress. But again, I mean, I think you have to keep in mind that there's a distinction to be made between marketing calls and debt collection calls. So I think that, just on its face, the 8 to 9 would still rule.
And just to add on to that, I think that if for some reason that 9 to 5 did pass, which I can't imagine it would, there'd be a lot of upset people if they reduce those calling times from 9 to 5 at the federal level. But the FDCPA kind of matched the 8 to 9 at the federal level before, so who knows? So even if the federal rules did happen to pass and reduce it 9 to 5, the FDCPA may take a look at it and reduce theirs from 9 to 5. I don't know, but again, something we're watching.
Right. Good point.
All right. Well, it looks like that's all the questions we've got. So thank you all for joining us today. And if you have more questions or want to talk about either technology or compliance consulting, our contact information is there on the screen. Feel free to reach out. Otherwise, we appreciate you being here, and we'll look forward to talking to you next time.